Welcome to TruthStream. We're back with part two of our story with Celeste Ryan and joined by her father, Matt Ryan, where we're going to talk about the broken system. And with that, I think we left off, you hadn't had a trial yet, Celeste, but it sounds like there have been some developments. Do you want to start there?
Sure. First of all, hi guys. Thanks for having me back and my dad. Um, yes, when we left off, I was waiting to have my trial. I had been put on standby, which lasted a few months. And then on December 7th, I actually had a 2-day jury trial um, up
Wow.
in Washington, which was quite an experience. I learned a lot and yeah, finally got to kind of the tipping point for everything that we've been waiting for the last couple of years to just actually unfold and actually happen, and finally had it.
That's great. And for those of you that haven't seen part one, this might be a good opportunity to hear Matt's short encapsulated telling of the story, and that'll kind of catch people up. And for those of you who have seen it, well, now you all have Matt's perspective, which I think is vital to the story.
Absolutely.
What do you think,
And
Matt?
thanks for having me here today, guys. Appreciate it. So this is something that started many years ago, 2002, with my daughter and my son being rear seat passengers in their grandmom's Volvo 850. It's a little sedan, little Volvo, and they're well-engineered sedans. They're engineered heavily toward occupant safety, mostly for the front passengers, though. So they actually didn't design the back of the seating well for rear end impacts. So that was sort of neglected. But so my two children were in their grandma's sedan. They were driving on a very long straight road. They had two cars stopped in front of them. One of them was actually a person that I was familiar with. He was the fire district chief, and I had done some work with the fire department, and I had quite a few fire department patients. And so he was stopped pulling into a parking lot with a double yellow line, which is legal. If there's a parking lot to a business or a home, and you have to cross a double yellow line, then you can do it. It's a 2-lane road. So we had traffic, coming one direction and traffic going another direction, and he was waiting to turn across traffic. So I guess grandma stopped her car, not a panic stop, just came to a stop like a normal, regular person does. And then after being there for a short period of time, she was struck really hard from a work van that was a plumbing van in this straight, long road in the middle of the day, for no good reason that I can tell, other than just maybe watching the water or being distracted inside his vehicle. He just didn't realize that these cars had been stopped in front of him, and he ran into them. And this is a part of the road where people typically go faster than the speed limit because you're going out of town. And it's 35, I think at the time it was 35 miles an hour out of town. But people often go 50 out of their 60 sometimes. So, and I'm from Port Orchard, and I've driven that road a million times over my life. And there's no possible way that any regular individual could have been driving down this straight road and not seen that there are cars stopped ahead of you and then avoid them. So he ended up, smashing the back end of their car. My kids were injured in the back seat. Grandma was injured in the front seat, and then grandpa was injured in the front passenger seat. And so it was my children, their grandmother, and their great grandfather in the car. Well, I received a phone call. I was in my office, and I received a phone call from my patient, who was an EMT firefighter. And he said, "Hey, just want to let you know, I'm down here on Bay Street, and your kids were in a car accident with the grandma. Everyone's okay. They don't need to go to the hospital. There's no severed limbs. There's no bleeding, people. But you need to come down here and, what do you want us to do? Do you want us to transport them to the hospital?" I said, "Well, you checked them, and they're viable, right?" He said, "Yep." So I said, "Just keep them there. I'll come down. I'll retrieve them." So I came down within 10 to 15 minutes and retrieved him from the location and took him to the office and started doing what I do. Trained as a chiropractor, trained for emergency response, evaluated them fully. They did not need to go to ER. They were typical soft tissue, rear end, whiplash accident patients. So do what I always do, send them home, put them on ice, have them rest. And then you just have to wait to see what the outcome of this is for that individual. So we did that, and it turns out that my daughter particularly had some serious injuries with her cervical spine, and she also had some relatively minor at the time neurological condition, but not enough to like warrant like urgent care, or like some people think you should go right to urgent care. Well, we're primary care doctors.
And wait for
We
6
actually
hours.
determine if they need to go get urgent care or not from other providers. We're fully trained for that. So there was no good reason to send her off to urgent care or the emergency department, and so we didn't. And conservatively cared for them for a number of years. So fast forward to Celeste growing with these injuries and her brother growing with injuries. Her brother settled his case by himself without the assistance of an attorney. He had my documentation, and he had another opinion from a local chiropractor in California, and he settled it out for what was a relatively good settlement for him doing it himself with a soft tissue injury that did not have the same injuries that his younger sister had. So grandma was a patient of mine also from that car accident, and she ended up settling out her case also, but for a very small amount of money compared to what her injury was, which is very common to have these, people just decide they want to settle. They don't want to take it to court. They don't want to fight. They don't want to, go through the trouble of it. And then Celeste, over many years, we discovered as we went through more testing that the permanency of her injury and the type of her injury was excessive for adults to have in those types of accidents, but common with children involved in those kinds of accidents. So we did conservative care, like I said, and then went to see some specialists, and the specialists were rather ineffectual and didn't add anything really to the curative treatment, and her conditions are not curable. So they're just things that you have to live with, and so that has a cost to a person. There's abilities and disabilities that come from certain. I heard I actually watched the last interview you did with Celeste and Scott. I remember you talking about having broken both your arms and still suffering many years later. So you totally understand.
Yeah,
exactly. Like our bodies are our bodies. They are our vehicle that's going to move us through space and time while we're inhabiting them. So everyone has their own constitutional makeup. And at the time of that accident, she was 6 years old, coming on 7. And she was a small child, a small frame. And she wasn't like a big, strong individual. She was a 6-year-old child, rear-ended, with a severe impact. And while not having to be transported to emergency care, she still had serious injury, but cared for by a professional specifically trained to deal with people who have had these injuries and to conservatively care for them. And I'm very effective and very well known for the outcomes of my patients being unusually good. I actually care about my patients, and I find strategies that work for them and help them overcome their issues all the time. But so fast forward to Celeste, starting this trial to prosecute the people who are responsible. And the responsible parties are literally the responsible parties. They are where the rubber meets the road. They're the ultimately responsible individuals. So the corporate entity is, embodied and enlivened by a CEO. The corporation is a dead entity. It's a paper entity. but it's enlivened by an officer of that dead entity, acting as if it's the dead entity, but it's not. So the CEO is just an employee of the dead entity, right? Shareholders actually have no liability whatsoever for the debts of a corporation. So a shareholder position is shielded. So they're not a party, and they have no risk because they're a
That's
shareholder
called the
of the
corporate
profit.
veil, by the way.
Right.
There's a corporate veil there that protects private individuals from their personal activities. Yes. Then there's the employee of the company that actually did the injury and did cause the accident himself. And I think in part also was caused in part by the failure of maintaining the vehicle appropriately by the corporation. So like it's unusual for a person involved in litigation to have a medical condition and have their medical condition be completely absent before the event occurred, and have their father or their responsible, guardian know the person beforehand fully. Like, I actually created her. Literally, I'm half of the equation that created her. I created her. She lived with me for the entire time before this accident. I knew what her capabilities were. I knew what her normal was. I knew what her medical conditions weren't. I knew her intimately because she's my child. I know her patterns, 100%. She gets involved in a car accident, and then I know my training is to determine what was injured. So I figured that out. And then I do the treatment. There's no curative treatment that's available for these types of injuries. So we just simply mitigate, coping essentially, and then teach your strategies, how to deal with these things. So most people involved in, any type of injury does not have their treating provider as their live-in roommate, and then become their treating doctor, and then diagnose them completely for their conditions, and then treat them, and then live with them still, so that they can constantly ask, should I do that? Should I do this? Should I, what should I do here? They have a live-in healthcare provider that helps them through that condition as they grow through time. So this is an unusual situation in that regard because I know too much. I'm not just a doctor that somebody came in and saw, and they told me what the problem was, and I examined them and said, well, it looks like it, it's this, and it looks related to that. Mm-hmm. But I don't know because I'm working off of what they tell me as the details. Like, I didn't actually witness the car accident, at the scene. I didn't see the scene. But in this case, I did. In this case, I saw it. And I drove down to it immediately. I saw the condition of the automobile that she was in. I saw the back end that was smashed, and I understand the forces involved. I saw the striking vehicle with no damage, and I understand all the mechanics that go into auto injury and auto collisions. So I knew what I was looking at. I knew exactly what to expect. And then I documented it, I found it, I proved it, that they were there, the things that I found during exam. So fast forward to this little, charade of justice. So I'm also, I've testified in depositions and things like that with other patients. And I've seen things from the outside of the legal system, and I only did my part outside the legal system. But this one, I actually got to see what's happening on the inside of the legal system as it happened also. And what I saw was appalling. It's appalling. It's a complete bastardization, a complete destruction of the justice system that was put in place on purpose for finding truth. And to see these players, these actors involved in it, actively avoiding truth and actively doing things nefarious to avoid the truth from being seen by a jury is worse than treason. Like it's a level beyond treason. It's the destruction of justice in our land, and it's disgusting to watch it happen. So, Celeste she came out of the womb, sort of arguing, like that's her thing.
I knew
Ever
that was
since she was
coming.
little. Like she just, well, why is that? Why is that? Why is that? Well, that's not right. I don't agree with that. So I'm not going to play with that. That's not right. So like they hit the wrong child, because she's a bulldog. She's not letting go. Like she's got her teeth in it. She's not letting go. And she's smart enough to understand, like as she goes along, of understanding the system she's working in, and then she can educate herself, because she was actually homeschooled for a period of time because of these injuries, and she had me and her mom basically encouraging her to learn how to educate yourself about anything that you want to educate yourself about. And then the beauty of going through that experience is that she learned how to find the things she needed to know and then apply it. So the crazy thing is that this thing happened back in 2002, and the internet, I don't know if you've ever seen these little memes that go around, but like things that didn't exist 22 years ago are like, Twitter didn't exist, Facebook didn't exist, like all the things that people think nowadays was always there, it was never there. Right. We were in the beginning of internet. Like we weren't like sharing information as rapidly as information is shared these days. So it rapidly escalated in the delivery of sharing information, and then everyone started putting online all kinds of advice and all kinds of information, and everything became searchable electronically. So all the rules of professional conduct for the bar are, you can look it up in 4 seconds. You can just go, well, what is that? And then you can look it up and then read through it and go, oh. And you can fact check like in real time.
Immediately.
Yeah.
And then Google, you can ask Google anything. You can ask, now Chat GPT, I guess, you can ask it anything and it'll just find it for you. Like, here's all the things you need to know about it. So I was going through a deposition with the defense attorney. He was asking me some questions. And he asked, like, basically, how does Celeste know what she knows? Because she should know the things she knows. This is a 30-year veteran defense attorney. He's used to dealing with.
Who's in his 60s, by the way, and doesn't probably know too much about the internet.
Well, now you've got a pit bull with a great legal mind and a legal library in her back pocket.
Essentially.
With the internet. So, wow.
And he said, how does she know these things? I said, well, she Googled it. And I think that was for him a realization, he's old school and he's got, probably books on the shelf. He's got to access them to probably find the case law. But I mean, that's what the legal system's up against. People with Google. Like when they say, I have authority, you go, well, let me just check that. What is your actual authority? How far can you go? What's your limits of your power? Oh, I'll be back in a second. I'm going to go online for a moment and I'll come back with knowing what the limits of your authority are. So unfortunately for this judge, and unfortunately for the defense attorney, and ultimately I expect at some point, it's too bad for the defendants that everything that their defense attorney has done in their name is extremely illegal, and they don't know it because they haven't been shared the information by their attorney, I think. And I don't know for certain because they might actually be aware, and he might be helping them to run their defense, which is just don't say a word and deny everything. And let her do her thing. Let's just see how good she will be in front of a jury. Well, the details of this case, I've never heard of or seen in my 52 years. Like it's unbelievable the lengths that the other side seems to have gone to avoid liability. And the strange thing about this case is that, like, they admit liability in part, but they don't admit it fully, because if you admit it fully, then there's a whole lot more danger to them for doing that. So they just admitted part of it. Yeah, we hurt her, but not that much, and oh, we know she's hurt, but we don't think it's worth that much. And so they hired these independent medical examiners to essentially determine whether or not she could have those conditions and whether or not they think that those are reasonable. So they hired these two docs, and a third one that was just an advisory opinion, who just reviewed documents and made her
We
weird
found out
opinion.
later was advisory when they were no longer going to call her after her deposition.
Yeah, and she was a neurologist, but we'll get to that maybe at another time. So ultimately, what is in place is that there's my medical opinion as a chiropractor, and only chiropractors can give opinions on chiropractic necessity. So you have to have a chiropractic license. So there's people in the industry, and I've seen this play out many, many times, where a person is injured in a car accident, the doctor does their best, the patient isn't quite, healed. They're going to go to trial because they have actual compensable injuries. And so they hire the IMEs, and the IMEs are called insurance medical exams by people in the industry, but their real term is called independent medical examiners. So you'd think that an independent medical examiner would come into an examination not knowing who they're working for. So you don't know if they're the plaintiff or the defense. They don't really, have the backstory on all the detail. So they can actually find the detail themselves, by doing a thorough examination and a thorough consultation and a thorough history, and then come to a conclusion, and then be given all the relevant, material facts behind that, and see if they were close to the people who already did it. They did it in real time as the patient was going through care. They decided, oh, this isn't going right. We need to do an MRI. You do the MRI, you find out the finding, and you keep on going. Well, an insurance medical examiner gets all the details of everything, scoops all the records up, reads through the entire thing, front to back, top to bottom, everything that's going to be going, possibly to trial. And then they know who they're working for. They know if they're working for the defense, or they know if they're working for the plaintiff. So it's not truly an independent examination with an independent, unbiased opinion.
Mm-hmm.
That's problem number one. So they did this exam. They came to these conclusions, and their conclusions are their conclusions. And whatever the reason they have a conclusion, they're entitled to their opinions. But their opinions have to be based on reasonable medical understandings, reasonable medical basis. There has to be an underlying reasonable medical basis for your opinion. Like, somebody comes in and says, I had a car accident and my arm fell off. And you do an exam, you're like, well, I don't see where the arm, had been reattached. I don't see any scars. I don't think that you actually did that. I don't think that actually happened. And then they do an exam and you find out the arm works just fine and all the sensory and motor functions are fine. And you go, I don't, my opinion is that I don't think that you had your arm fall off in the accident. And that's just your opinion. So they're entitled to their opinion, but it has to be based on a reasonable medical, basis. Well, I'm trained in virtually, all of the objective tests for musculoskeletal conditions. So with her IME, we actually recorded it, and then I went through it, and I
Which,
looked
hang
through it.
on, we didn't just record it. I want to always make that very, very, very clear. This was not like I had a phone in my pocket and I was like recording them. The
Right.
agreement in order for me to do the IME was that they needed to hire a professional videographer to do a professional video recording of the examination, and then I would pay for it. So they actually contacted and hired a professional to come in with a big old camera and record the entire thing. And then I actually didn't even end up paying for it. The guy was like, don't worry about it after watching the examination. He's
Wow.
like, here you go. You can just have it. Good luck.
Yep.
And like, I always want to make that very clear that this was not some secret thing. They knew that they were being recorded. They had set up the recording. It was a very like legal like matter of you're being recorded for the purpose of comparison. So this was all known beforehand. So go ahead. Just want to make that clear.
If I could interject, Joe had a question about they said what they should be charged for, but we've got the compensatory component of this case, and now we have what might look like malfeasance, malpractice, malintent on the part of the defense. So now are we
Unprofessional conduct.
Yeah, are we dealing with two separate components now and two separate compensatory categories, or
Yes.
how? Okay.
Yeah.
So each actor is responsible for their actions.
Okay.
So the chiropractor.
Sorry, but separately. So it wouldn't be that I have this civil trial for my injuries, and then, oh, you did all this wrong in this trial, and now that's going to get tacked on. It'll all be separate, completely different causes of action. So like if I were to do something and want to seek damages for the malfeasance part of it, each one of those would be independent and not actually part of the trial for the injuries, if that's what you were asking.
Yeah, like a case that would have like a civil suit that would be a completely separate matter.
Completely separate.
Right. Okay.
Yep.
Completely
And
separate, yeah.
those charges on the malpractice or malfeasance end, would that be, I mean, what would those charges look like? Just legal malpractice, criminal intent?
Oh, racketeering, so RICO violation, which
Okay.
is any kind of organized crime, which is, I believe, two people on more than two occasions conspiring to do something. Fraud,
meaty.
I mean, this is insurance fraud. If we were to reverse the roles and I were to go into court and I were to hire two doctors to flat out lie, to concoct and make up an opinion for me to go after them for millions of dollars, I would be charged with insurance fraud if it were to be found out. But for whatever reason, it's okay for the defendants to do that, and that's not considered insurance fraud. So racketeering, insurance fraud, lots and lots and lots of perjury. That's, I think we talked about this last time, that the funny thing about all of it is that this is a legal matter. It's all in writing. Everything that we do is in writing.
Not only that, but it's public record.
A good portion of it is signed under penalty of perjury. So they're basically saying that I'm saying these things, and if I'm wrong, then I get to suffer the penalties that come along with perjury. So there's that, collusion, corruption. There's a long list of the criminal acts. And then every single instance of those is its own separate. So it's not just like you lied, perjury. It's every single time you lied. And there's another thing called suborning perjury, which is every single time somebody lied and the court or an officer, like an attorney, was made aware of it and did nothing or protected it or encouraged it. That's called suborning perjury, and that's its own charge. So there's a lot of branches that come off of each individual act each time.
So now it's that component of the case is not so much concerned with compensation as with prison time potentially, or that kind of legal entity, right? I mean,
well, I would like to see that, and that's going to be my next battle, is because I've gone to every like criminal enforcement, law enforcement agency, and they've all made determinations to do nothing about it. So I've gone, I mean, I've filed complaints with the health department against the doctor's licenses, with the Chiropractic Quality Assurance Commission, with the insurance commissioner, with the attorney general. We went back and forth. The governor, we went back and forth. I called the FBI. They hung up on me. They said that this is just kind of not really something they do. I've tried to go down to the police department, and they had me fill out a little information, and I filled it out and it went on to the back, and they said, whoa, whoa, whoa. Can you not give us so much information? I've tried going to the prosecuting attorney for Kitsap County, and I couldn't even get past the secretary. They wouldn't even let me come and talk to the prosecuting attorney, who, by the way, worked as a defense attorney for my judge when she was in private practice, which is, you know, can come to your own conclusions there. Yeah, I've pretty much pursued every single legal remedy as far as criminal that I can. They've all determined to do nothing. And so now I either need to learn how to privately criminally prosecute or just simply privately civilly prosecute for these things.
Yeah, you know, I may be way off on this, but it's beginning to sound like the deck might be stacked against you here.
A little bit.
Now, are you,
little bit.
Joe was just pointing out, do you see collusion as an element? Do you think these agencies are protecting each other? Or is it just the fact that you're the defendant, that this is kind of just how things work in an unspoken way? Or
So what I think about the entirety of it is, again, like we've gone over the extremely unusual circumstances and the way that things have played out. Like, you know, my dad's like, I just happen to be one of these people. I don't know why, but I just am a very like righteous person, and I don't like, you know, bullies, and I'm like, you know, a little bit fearless in the sense of like, what are you going to do to me that, you know, like you already hit me. You know, what? And so the circumstances surrounding everything, the fact that I am able to prove something from so long ago, which I think we also talked about this last time, that in most places you have a statute of limitations. You've got 3 years. So I was 6 at the time. By the time I was 9, if that had been my statute of limitations, I would have been in 3rd grade. We would have had no idea the full scope of how this would have affected me. You know, it's been 20 years now. We just passed the anniversary. And I grew with it. I learned how to, you know, ride my bike. I learned how to read. I learned how to, you know, do all of the socially interact. I got my first boyfriend, my first car, my first job, everything with these conditions, which most people don't have. And as an adult, there's less firsts, you know, like I had, but you still have all these experiences. Imagine if you had, what if you had 20 years to do something about your arms? You would know with absolute certainty that you're left with what you're left with, and it's not going to get better. And it would drastically change your valuation of what the injury was. So not only did I have the statute of limitations because I was a kid, but because my dad's a doctor and because he's a chiropractor, which is its own separate whole thing, and knew the ins and outs of the industry. I mean, he stopped billing because they wanted to send me to an IME and was like, nope, because we knew, or he knew at the time, what those are. They're frauds. They're fraudulent. And said, no, thank you. I'll just keep treating her. Don't you worry about it. That's my kid. He's not going to be like, you have a super bill of $100. I'm not like, you know, he's going to just treat me. And the fact that, you know, it's also not just like, Dad, I have a headache, but Dad, I have a headache, and you're going to adjust me, and then you're going to write it down, and then you're going to image it with special imaging equipment, and then you're going to write that down. Like, just the series of events, the circumstances of it are that I can prove that soft tissue injuries, particularly in children, have lifelong consequences and therefore have lifelong costs associated with them. And
let me pause you right there for a second. Let me pause you. So the important thing to know about like law is that there's a group of people in our Congress who write laws for the protection of our rights. And they wrote these laws, many, 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 many years ago before this car accident happened, for this exact situation that happens with children. Children get some type of injury or an illness, and then they don't know what the effect of that's going to be until they actually, live through it. And either it resolves and their life goes on as normal, or it doesn't resolve, or sometimes it recurs. But you don't know how it's going to affect you until you have enough time to know, is it going to come back and get me later? Is it going to affect, my ability to perform in a new job that I just picked up a new job and I have to do something different and I can't do it because my left arm doesn't work really well. So you're actually excluded from being able to do certain activities. I want to be a professional football player, but I had a back injury when I was in a car accident at 6, and now I can't be a professional sports, entertainer.
Which I actually thought I wanted to play professional soccer, and I had to quit at 16.
Wow.
So there are those things that happen, but then
so let me back
you
up.
have the medical side of it. Okay.
So the important thing is that we have, for children, 3 years after the 18th birthday as the statute of limitations for children on purpose because of that. And the defense has never liked that Dr. Ryan and Celeste's dad decided not to settle the case when she was a child for her. Instead, I said, in fact, there's a recording of me that they won't admit, and I'm certain that they have it. When the insurance company from the other side called me one day, about 3 months after the car accident happened, and they said, hey, just checking to see, how's your daughter doing? And we'd like to close this claim out. Would you take, a couple $1,000 for this? I said, no, there's no chance of this. This is a severe permanent injury, and we're not going to settle anything under policy limits. So 3 months into knowing what I had in front of me, the injury degree, I knew that this is a lifelong problem. 3 months in, I knew it relatively sooner than that, actually, but by 3 months, I knew this is one of these cases. These are not going away. They're not going to heal. They're not going to go away. This is something that's we're going to have to watch this over years. And then we need to see how it affects her. So there's no chance I'm going to settle unless it's at policy limits. And policy limits were $5 million, to my knowledge at the time. So imagine like knowing 3 months in, not just like, no, I'm not going to settle for 3,000. I think it's worth 12. Me knowing from my training and my understanding of what happened, what was sitting in front of me, the lifelong trouble she's going to have with this. And then saying, no, it's not worth it to her for me to settle the claim for less than what I know is going to cost her the rest of her life and suffering. So if you want to talk about policy limits, we'll talk about settling at policy limits. Then the defense attorney goes back into that file, and I'm certain, because they're required to keep the recordings, I'm certain he listened to that and realized that I knew what I was talking about at the time. I still know what I'm talking about 20 years later. And this is not something to be settled for, $20,000 or $50,000 or even $3 million.
Yeah. So take that whole thing of, again, having somebody being able to identify it so early on. Another aspect that I think maybe hasn't really been said or anything in like the case and all that, but surely they're aware of, is a lot of the time what they do. I mean, it's all finger pointing. Well, you didn't do this and they didn't do that and blah, 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 blah. And a lot of what kind of cases like this do is the defendants will maybe not blame the plaintiff for the injury or, that kind of thing, but they will blame and they will try and assign blame in the mitigation of that injury. So you didn't see somebody soon enough, or you didn't follow your doctor's orders to a T. And so now aren't you kind of responsible for you not healing appropriately? So the other aspect of what my dad was saying earlier, living with my doctor, is they really can't point to like, well, you didn't mitigate this well enough, because number one, you look at me and I'm pretty functional as far as like the way that I can be because I know so intimately how to handle myself and because I know how to manage my conditions so well that I can at times be a normal person. Um, that has consequences to it later, but at least when I have to show up, I can. And in all of that, like if I was jumping on the trampoline, I had my doctor there. If I went on vacation, I had my doctor there. So the mitigation of the injuries in itself is another huge aspect of it, of doing everything right and still like doing the best possible scenario and still coming to this where I have permanent severe injuries that they can't really shift the blame of, well, didn't you just not see somebody enough? No, I saw them all the time. Well, didn't you just do this one thing where you played sports and didn't that just really do it? No, because I brought my doctor and I was trained in how to, I didn't have my coach telling me, hey, you need to slow down, or you like, I knew what to do. I knew that I had to go home and lay on a cervical roll when I was done with my soccer practice after taking a shower to relax my nerve. Like I know this stuff. So they can't blame me for that portion of it as well, which is another problem that they've had with my dad being a doctor. We mitigated it too well. And we mitigated it so well. And with all of those efforts, still didn't come to a very good outcome, means your liability is huge. So that's another big aspect of it.
It sounds like if you're a child affected in an accident similarly, and your treating physician isn't a live-in family member, you don't stand a chance.
Well, there's
You don't.
well, there's also the cost of like having professional guidance continuously.
The
Like,
time.
how much money do you have to have a live-in doctor, take care of you on all your off time and all of his off time? Like, you couldn't afford me.
Who's emotionally invested as well, by the way. Isn't just, oh, you're getting paid $12 an hour to come and watch this person and you live it with them and do whatever, but you have the most emotional investment because it's your child. Like my dad there's no ulterior motive to anything other than what is the best we can do because you're my kid. And all I want for you is success and happiness and peace and all of these things. So it's not even like even going to a medical doctor where you could call into question, well, why'd you have him on this treatment plan for 15 years? Was it just so you could be getting this massive payout so you could just keep treating somebody and just have that guaranteed, cash inflow? There was none of those ulterior motives to even question it in the first place. Why did you treat her so well or so often? Or, it was
When you need it.
it's so pure. It's so pure. We're going to do every single thing we can to get you to a functional point, which I would say he's done pretty well because, I've had doctors that are like, how are you in here like moving and walking? And I had my chiropractor in California who read my dad's like reports and read through all of his medical records and came to me and said like she was crying when she read through my records.
Wow.
Because it was just so like horrible, honestly, if I'm. But back to your kind of original question, like all of these little tiny aspects and little specific parts and pieces. Number one, I will say, you cannot be lying and have all of these little things fall into place. You can't even know about all these little things that have to fall into place for it to look like truth if you're lying in even one single instance. You can't. It's impossible. Especially when you're in this adversarial thing where they're trying to pick everything apart and they found zero to pick apart. And
so that gets us to the next phase of that. Like, if you are a defense attorney and you need to avoid telling the truth, you have to eliminate anything that could be seen by the jury that would allow them to discover your fraud that you
which in this case is everything.
It's
In
essentially
this case was everything, and it turned out that way in the trial where I wasn't allowed to do anything at all. Nothing.
How do you mean exactly? I'm not sure I understand. In this most recent trial?
Yep.
Yes.
You
So we
weren't allowed
finally
to-
did get to the trial, which happened in December, and now we're, making our way towards appeal. But basically, some stuff I was prevented from, so I wasn't allowed to call my dad as my doctor or as my dad. I couldn't have him testify. He was excluded entirely from the case.
By a judge.
On what predicate?
Oh,
So I actually was a little bit more prepared this time, which I don't really know how to do this, but there was an order that I had against me, and it was the very first thing done in the case. It was the very first motion that was done, where basically
by the defense.
by the defense. So I think I mentioned last time that I had found like some fraud that had happened in discovery with the maintenance of the vehicle. That they had attempted to alter the evidence and alter the documents to make it appear as though they had a working vehicle and it was safe to drive and all this stuff, which as a public corporation, or a private corporation, but working in the public, you're required to maintain safety. That's the whole thing. It's why they have such a large insurance contract, is because you can't go out in commerce and endanger the public. You can't put the public at risk for your own, commercial activity. You're supposed to take extra precautionary measures to protect the public. And that wasn't done. They put an improperly working, particularly the brakes were not properly working in this vehicle. They put it on the road knowing that they were not in working order because they had been warned several times by their in-house mechanic, hey, the brakes are pulling, you need to check out the brakes. So they tried to alter the evidence to show that, or make it appear as though they had fixed the brakes and then they were in the accident. And then I basically caught them where they didn't fix the brakes until a year after the accident almost. And then they maintained the vehicle for 16 years. And a month after I filed a lawsuit and after they had retained defense counsel, they sold 2 of their vehicles, but they had the one that was involved in the accident destroyed.
Ooh.
So
Crushed.
it was crushed. They scrapped it at a scrapyard and never seen it again.
You mean the evidence?
The
That's
evidence,
exactly
right? So, right,
Wow.
destruction of evidence, spoliation of evidence. So, basically, I had also gotten their insurance jacket, which is their humongous. It's the entirety of their insurance contract. And I read through it, and there's a portion in there that basically says that any attempt at fraud on the part of the policy holders voids the entire policy. So when I was going through these things and seeing that their attorney was sending me this evidence of them committing fraud, you can't destroy evidence in an attempt to limit your liability in an insurance case like this. It's not an insurance case, but they do have insurance. My first kind of instinct with that is, oh, well, the defense attorney works for the insurance company. He was hired by the insurance company. It's an unspoken rule. It's this, duh. And so when that happened, I reached out to the attorney himself and I sent him a letter and I said, hey, I'd like to sit down and, discuss a possible settlement. But the only way that I'm willing to do that is if the defendants are actually there as well. And he sent back another letter saying that I didn't have the authority to talk to the defendants directly. I had to speak to them or to him as the attorney. And then I wrote back, I don't really think that that's true. Parties are allowed to communicate with each other. And at this point, I was asking him, did that come from you or did that come from them? And if it came from them, can you just give me some kind of a confirmation, have them sign something that's saying that they have received this invitation to sit down and have a little meeting and talk about this whole thing. and that you're not just running interference and making this determination for them. And he responded with, you don't have the authority to contact the defendants directly. So I didn't.
If that
And
attorney,
then he,
I'm sorry, but if that attorney was acting on behalf of the insurance company as well as the defendant, but hired by the insurance company, I would think that would nullify that relationship where if they commit fraud, because it's in fact the agent of the company, the insurance company, engaging in fraud, and then there's a greater liability than brought directly on to
right.
the insurance company, right? Because now they've opened up a third component to this case, it looks like. Do I have that right?
Right. So that's where it started. That's where all of this all this nonsense started. Was, I think that, and this is like, I don't have like evidence to back this up. This is just like my experience and me going through this whole thing. I think that the attorney was trying to have me catch the evidence tampering and the whole thing, and I think that he was trying to get me to, because he is under, you know, obligation where he can't say it, but if I bring it up, if I catch it, and he's just supplying discovery requests and I happen to catch it, and then I say, hey, you just committed fraud, and then the insurance company is off scot-free. What I don't think he was intending for me to do is to say, well, you're doing it on behalf of the insurance company.
Bingo. Wow.
Which is what I did. And
of course.
so now they're stuck with it. And now if they were to say, well, they committed fraud, they would be able to back it up and kind of like, the insurance company is now kind of stuck where they can't like say that I was maybe right about that, because, you know, that would be even a bigger problem.
Does the
So that's
insurance
where all
company
of
have
this
new?
started.
Does the insurance company have new representation now, or
Not yet,
No.
surprisingly.
They
really?
won't through appeal.
So they've kept the guy that engaged in the fraud that opened them up to the liability.
Well, that's what I mean. I think they can't like admit that I'm ever right about anything, because if I'm right about anything, I'm probably right about everything. And so that's where it all kind of started, with this whole kind of back and forth thing. And so then the defense attorney went to the judge and tried to get a protection order where I'm not allowed to directly speak to the defendants because of the rule of professional conduct between attorneys, RPC 4.2, which says that attorneys are not allowed to talk directly to represented parties. So if I was a lawyer and I knew that the other side had a lawyer, I have to talk to the lawyer. I cannot talk to the actual parties without their consent. But I'm not an attorney. And I don't follow the rules of professional conduct because I don't have a license for that, and I didn't agree to that. So basically I said that, and it's funny because I didn't actually go to the hearing. I was in California and I couldn't attend, and at that point I didn't even know all the workings of everything, that you could do appearance by telephone, that kind of stuff. So I had just answered it, filed the answer, and then I didn't go to the hearing. And I actually have the transcript here that I can read. I don't know if I can show it, but I can read it.
Should be able to share screen.
And the attorney said, and yeah. I'm
Yeah,
so
on the
bad
bottom
at
of
this stuff.
Zoom, share screen. Bottom panel, share screen.
God, I just love the way you guys have managed to frustrate the situation just out of circumstance. It's fantastic.
That's actually what happened. It just compounds, and the next thing compounds the next one, and then you go, well, that you can't do that. Like, that's not okay that you do that. And they're like, and nobody stops them, and then they do it again.
You're just 20 years old. You're into this.
Hey, baby.
Right.
I don't know how to do this.
God.
Well, maybe.
I'm gonna be.
Sorry, this stuff is so bad. I'll just read it because I don't know how to put it up there.
Sure.
But it says, and Your Honor, The other thing, I don't know if I made it clear, and I'll make sure that it's clear in the order that I propose and submit ex parte, is does the no contact also include her father? I think his name is Mr. Matt Ryan. Then the court says, I don't think the court has authority under this action to do that. It may be that the minutes need to seek separate remedy, but he is not a party to the action. So this is actually important because they literally asked, does this include my dad? And the court said, we don't have authority to include him in the order. He's not a party to the action. So fast forward all these years and all this stuff that they've been doing and the fraud and everything. And hey, Dad, do you happen to know anybody?
Yeah, I definitely did. And you spoke to this a little bit in the first recording. So there's people that I went to high school with in Fort Orchard. Kyle is my buddy, and his brother has always been kind of a jackass, but he's married to the CEO of this plumbing company that struck my daughter.
Oh.
So I was watching all this play out, and the whole question was for Celeste asking the defense attorney, like, okay, I want to meet to discuss and negotiate our settlement, but I want to do it with the parties. So the parties are allowed, clearly in all law, the parties are the only ones who actually have the power to agree to a settlement of their dispute. The attorney is advisory. The attorney is there to advise his clients. He's not a party. He can't.
Yeah, it's even in the RPC rule that he used that the parties can meet.
Yeah, so he said, Celeste, you can't talk to the party because you're acting like an attorney. And because you're acting like an attorney representing yourself, which is a weird thing that happens in the legal system, where you're not yourself. You're acting as if you're something other than yourself, though you're actually yourself, right? Unless you're an attorney. If you're an attorney and you're in a car accident and you represent your own interests, then you actually are an attorney with a bar card. And then you are held to the same standards as a pro se, because in one moment you're an attorney and the other you're the person behind the attorney. You're the actual individual, right?
Right.
So Celeste says, hey, I want to meet with the parties. I want to talk about what happened in the car accident, and I want to talk about, when it was injured, and I want to talk about settlement. And the attorney, basically said, you can't do that. And she said, well, did you actually present the offer? Because you're required as an attorney to present any information to the parties, because the parties are the ones making the decisions for their defense and prosecution. So she says, did you actually present that? Well, I don't have to tell you that. Well, how do I know if you got the information to them or not, unless you tell them that, hey, the injured party wants to settle and they want to get together with you to settle. I'll facilitate that. I'll help you make that happen. I'll be there with you to advise you. Don't say this, don't do that. She didn't say, I want to meet with them alone and I don't want your attorney there. She said, I want to meet with the parties with the attorney there. So he said, no, you can't do it because I'm going to presume that you're an attorney. And because I'm presuming you're an attorney, I'm going to pretend you're actually an attorney with a bar card. And in the Bar Association, which is a private association, it is not a government institution. It's a private association. They have private member rules, and you have to be a member to be subject to their rules. So they're essentially offering to make her an honorary bar card, attorney, because she's acting like one, so that they can hold her to the RPCs, which are rules for professional conduct as an attorney. It's the same thing for me as a chiropractic license holder. They say, well, you're a chiropractor, you have the skill to adjust bones, but if you're going to do it in business and you hang a shingle, then you have to have a license to hang the shingle. And then if you hang the shingle under the license, you have to agree to these sets of professional conduct laws. And I go, okay, that's cool. I'll do that. But if I was not licensed and I was just cracking bones on people, I still wouldn't be acting as a chiropractor under a license. I'd be acting as a non-licensed chiropractor. So they're trying to say that she's an unlicensed lawyer because she's
Hi.
presenting her claim in court. And you can't do that if you're just the individual presenting your claim. You have to have representation, representing. Somebody has to represent your claim to the court. So they're holding her to the standard of a bar attorney, and they're holding her under the private bar rules, and says that you can't talk to our clients because you have to talk through us. So she said, well, and she's telling me, she's like, he's not getting the information to them so they can make a decision. They can make come to a common agreement with all the information, understanding all their risks and understanding all their liabilities. He's blocking them from having that knowledge. So I said, okay, well, I went to school with Kyle and I know his brother Brian. So let me get a message over to Kyle and see if his brother would be interested in talking to me, because I know a lot of detail because I'm watching her go through this thing. And I'll tell him, hey, here's the stuff you should know. And if you want to take it back to your wife, take it back to your wife. She's the CEO of the company. She should have this information. I don't think the attorney's sharing it with her. And that's unprofessional conduct on his part. You should have the information. The other party should have the information. So I did that. I reached out to him and I said, hey, Brian, this is Matt. And, I think that your wife is the CEO of the company that struck my daughter, and she's trying to, get to meet up with her. And so I did it through LinkedIn. And, it's a really scary message. If you read it, you'd be appalled. You'd think, this guy is coming after Brian. Because I said, hey, I think that you should have this information so you can make the best decision.
Yeah.
And it was really scary.
Yeah, it sounds like intimidation to me.
It's super intimidating. Yeah. Yeah. Hey, oh, by the way, so Brian and Kyle and 20 other of my friends from high school went down and golfed together for weekend tournaments, and we played in tournaments together, our private little tournaments, and we partied all weekend down in Reno and down in Las Vegas. And I've known Brian and Kyle since 11th grade in high school. I was on the soccer team with Kyle. Kyle was in a bunch of my classes. Kyle and I played poker at his house, his mom and dad's house, where Brian lived, and came in and out and joined us sometimes. And I know Brian like I know any other close family friend. And I said, Brian, hey, it's Matt. You should probably know about this. And then Brian, through the attorney, said, that was scary and threatening that he contacted me out of the blue. I don't know him.
Clearly.
I don't know who this nut job is.
Wow.
Coming after me.
That was his claim?
Before we get into all of that.
Yeah.
Essentially, that's what the defense attorney claimed, is that he didn't know me. He wrote a statement, a declaration saying, I don't know who this guy is. So I sent another message back to my buddy Kyle. I said, so you might want to say something to your brother, because I don't think that the courts look kindly on perjury. Like, Brian's trying to say that he doesn't know me. And we went to, I can bring in 20 guys and we'll all talk about how Brian and I golfed together weekend after weekend, and how we
yearbooks. Yeah.
I've known him since high school. And
which he then backpedaled and filed another declaration after that. Like, oh wait, okay, I guess I do know.
Right. Oh, I know that one. Yeah, sorry.
I thought you were talking about a different guy. Well,
Right.
Let me interrupt for just a moment.
Like,
I'm sorry. We're at about an hour, so just for the audience, it's nice to break it up in hour segments. This being the second of two. We'll go ahead and keep going with part 3. It's getting really good, but to the audience, please join us again for part 3, and we'll continue on with this exciting story. Exactly.
awesome.
Thanks.
Awesome.